The 1992 Constitution does not provide a cap in terms of appointments to the Supreme Court bench. Incidentally, what is provided is the minimum number of judges that can be accommodated at the apex court. According to Article 128 of the Constitution, the Supreme Court shall consist of the Chief Justice and not less than 9 other justices. Currently, there are 14 justices at the Supreme Court. The President has recently nominated 4 more who have undergone vetting in Parliament. 2 of his nominations have been approved by Parliament, while the fate of the other 2 remains unknown. For some analysts, constitutional powers given to the President to appoint as many as he so pleases is not the best for the country.
Article 128, for emphasis, I quote, "The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court." Mr. Speaker, not less than 9 other. So, Mr. Speaker, as you rightly observed yesterday, it is not your power to interpret the Constitution. But, Mr. Speaker, where there is no ceiling provided, I want to believe that the framers of the Constitution assume that Parliament will provide for those limitations. We cannot have an open-ended. So, Mr. Speaker, tomorrow, if a particular president decides that he wants to appoint 25 justices of the Supreme Court, we will say because of jurisdiction, because of supervisory role, because of adjudicative role, it must be. That is what this Constitution provides. But, Mr. Speaker, it has always been my position that Ghana does not need more than 13 justices of the Supreme Court, because you can empanel from 5. The Chief Justice can empanel from 5, expand it to 9, and expand it to 13. That should be it. So this Parliament somehow must find a way to limit the numbers of justices of the Supreme Court that the President can appoint. We have seen President Akufo-Addo take full advantage of it. He has appointed more Supreme Court justices than any other president has done under the 4th Republic.
Others hold a different opinion. They believe the remit of the Supreme Court is so wide that it justifies the current provisions of appointment to the Supreme Court. The Speaker of Parliament espoused these sentiments while he announced the approval of Justice Barbara Frances Akayensu and Justice Samuel Kwame Adibo-Asiedu to the Supreme Court.
The House has, by this adoption, approved the nominations of His Excellency the President of the following persons as Justices of the Supreme Court in accordance with Article 1442 of the 1992 Constitution. The persons are Justice Barbara Frances Akayensu and Justice Samuel Kwame Adibo-Asiedu. As for the number of judges in the Supreme Court, I will go with those who think that the remit, the jurisdiction of the Supreme Court in Ghana is so wide, so large, is so huge, that the framers of the Constitution did not just leave that for Parliament to legislate, to give the limit. It's for good reason that they only gave the minimum and left out the maximum for good people in government to at any time determine the right number. Unfortunately, politics has entered into this arena. I recall a few years ago, the insistence was 13. And during discussions, it was agreed 15. Today, the discussion has shifted. You can't lead a country that way. You can't govern that way. There is no meritocracy in this country, and we need to work towards that.
The first Deputy Speaker was also of the view that broader consultations be made with the judiciary before any decisions are made about capping Supreme Court judges.
The numbers may even be increased. Indeed,
Some of them suggested that we should have not less than 5 or 6 separate courts because they have separate and different wide jurisdictions. So, as a major stakeholder in justice delivery, I think that we should discuss further with them. No decision should be advocated or implemented by the political arm only, but the judicial arm, which are the major stakeholders, their views should be considered, in my view.
Also in Parliament, the Speaker called on the Electoral Commission to further engage the House on the constitutional instrument that seeks to make the Ghana card the sole document for registration for persons who have attained the voting age leading to the compilation of the voters' register for the 2024 elections.
The Electoral Commission is giving notice. I believe it's not the case, because they know they cannot go on the offensive against an arm of government. We are not just a state institution. We are not just an administrative body. This is an arm of government. And when they talk about independence of arms, they really mean that neither arm, whether the executive or the judiciary, controls the other arm. We don't also control the executive, we don't control the judiciary. That is what the separation of powers is all about. We have to work together because we lead the country, the three arms. And so there is no way that a subsidiary body can be on an offensive. We passed the law to create the Electoral Commission. It was simply guaranteed in the Constitution, but we had to pass a law to establish it. I hope this is enough notice. I must be given the brief before I can exercise my authority to allow the business to be provided and presented to the House. But I'll cross-check to make sure that the official communication has been given. I don't take the peace of this country for granted, and I will not do anything to endanger it.
The House adjourned today's sitting a bit earlier than scheduled to allow for members on the minority side travel to Cape Coast, where the NDC will be having its women's organizer and youth organizer elections this weekend. Now, from next week, though, it is expected that committees that have received budget estimates from the various MMDAs will submit their report to the House for debate. From Parliament House in Accra, Charles Osukumi for Citi News.